speaks on that. Therefore, there were laws occupying the field. Then what was the need? There lies the whole issue on which we have to fight it back. The need was not constitutional governance need, it was a political need. How come this political need issue comes? You see, after 2014, RSS, after a long battle, came back to the constitutional administrative authority. Once Ambedkar is many times mentioned, while these constitutional debates were going on, it was expressed, we are going for one vote, one value, one person theory. But what would happen if ultimately we find that the majority of the people, one vote, are guided by their religious sentiments and voted to power a particular religious authority, which had come into effect in 2014. Since then, the Modi government has been trying to pursue that India is not a country of diversity. India is a country of one nation, and that's the background in which they have been proceeding to govern. Now they had introduced this concept of introduction of uniform civil code, though it's a part of directive principles of state policy, but number of times it has been discussed that it is not practically feasible and realizable in such a big countries having diversity, the uniform civil code. Now then, how to introduce the concept of Hindutva in law? 2-3 important events you must keep in mind. With deepest of respect, I am making this point before you are all my good friend lawyers. And when the second term of Modi came to power, he had been campaigning all throughout, being the Prime Minister of the country, all the nuances of Hindu philosophy, and ultimately that arrived with the establishment of Rama Mandir. Respect to a particular mythological head, a mythological leader. Ram is definitely a mythological leader, commands respect to everybody. But bringing that mythology into the reality in the form of history is one of the dangerous strains in the whole world we have seen before. Now with the establishment of Ram Mandir, now we find after this statement of retired Justice Chandrachud that the Ram Mandir judgment was not a judgment on the constitutional conscience. It was not a judgment based on logic. It was not a judgment based on history. And if you have gone through the judgment, reading its entirety, you will find that there was no logical conclusion to that. Now the logical conclusion comes, the author of the judgment, which we had initially anticipated that he must have been the author, he says he was guided by God. And who was the God? You see, after Rama Mandir Pran Pratishtha was done by who? A political leader, Mr. Narendra Modi. Religiously, who are religious people, they always believe that this Prana Pratishtha is done by the priests of high order. But here this Prana Pratishtha was made by Narendra Modi, and thereafter he claimed himself to be a non-biological person. Don't forget this, don't take it as a mere, mere comic. He claimed to be a non-biological person, and that means he is the direct descendant of God. Now, direct descendant of God who could Prana Pratishtha of Lord Rama, now they want to utilize the constitutional machinery to bring about the Brahmanic idea and culture in law. What is said when the law is introduced? Law was passed when number of MPs were suspended. There were almost no opposition members were there. It was said by Amit Shah, who was introducing the law, these bills. He said, this bill these criminal bills, Indian Evidence Act, Indian Penal Code and Code of Criminal Procedure, though Code of Criminal Procedure was enacted in 1973, not in the Parliament of England. He said these laws were enacted in the Parliament of England. Therefore, we have to amend it. We have to replace it and make it a law made by the Parliament of India. Now, what is the corollary? The corollary is Transfer of Power Act, by virtue of which the power of governance was transferred to the Indian people, was passed in the Parliament of England. The Independence Act, the Indian Independence Act, it was passed in the Parliament of England. Now, would he mean to say that if he could get it through, tomorrow he might come forward and say that Indian Independence Act was passed by Parliament of England. Therefore, I repeal that act in the Indian Parliament and I say this is a Rama Rajya, Rama Pratishtha. That is the philosophical outlook which brought this law into effect. And what is the enactment made? The Samhitas. This is purely Sanskritic outcome of Brahminic philosophy. Manu Samhita. Do it in a slow poisoning manner. Keep it in the mind of the Indian people that Samhita, that is the law, and our forefathers had Manu Samhita. Therefore, Manu Samhita would be future guidance of the Indian ruling classes. That was the whole purpose. That's why these three laws were enacted. Otherwise, you won't find, I am not going to comparative analysis, the 95% of the old act is copy-paste here, except the change of order. And just for a broad reference, you will definitely go through it, your lawyers. This law is misogynic. Here the concept of woman from Manu has been very cunningly incorporated. The law says, you must have seen, that if two persons have sexual interactions with the idea or promise that he will get something, then if she does not get it, then it becomes rape. If she gets it, it is not an offense. Meaning thereby that you can have sex in exchange of getting something. Is it not encouraging prostitution otherwise? Is it not that you are thinking the women are still should be under the thumb of the male community, which is the idea of Manu? It says that we have removed the colonial concept of sedition. But what have you brought in? You have brought in the idea of sedition, which is worse than the idea which was reflected in Indian Penal Code. At what point of time? When the Supreme Court said that you cannot apply sedition provision under the Indian Penal Code any further. Then they changed the law. Only the jacket is changed, but the basic materials are worse. Now, this speech of mine before you can also be said to be is really interfering with the sovereignty of country, and I can be taken to jail. He was talking of UAPA. That was a special act. Now, the UAPA provisions have been made a part of the Principal Act. These are the dangerous strain against the basic democratic right of the people. That's why we think that this matter should go to the common man. They are affected. The question of bail. So long it was the practice that first 15 days is the authorized police custody. Now it says no. This 15 days police custody can be split up. And if you cannot file charge sheet, you are entitled to get default bail. Now the police are being trained. They will say just on the 58th day, no, I need this person in police custody for another 2-3 days. There was the possibility of getting bail, which is the basic right of any individual in the society, is cunningly taken away. Now, who is going to be affected? The common people. I tell you, the affected people would be the weaker section of the society, who are forced to commit offences because of their poverty, because of the lack of culture, because of the lack of education. They will be thrown into prison, and the upper class people will be very happy to see it. The another serious provision which would ultimately affect the common man's right, if you violate any prohibitory order consecutively for 3 times, then you don't have any right to ask for bail. Now every day we go and violate 144, I mean erstwhile 144, now it's 167 or something like that. This is deliberately done to express your anguish and grievances against the administration. Now administration will come and say this gathering is declared to be unlawful, and if you are a part of it, you have committed an offence. If it is more than thrice, and you don't get bail. These are the provisions which are there. Criminal laws are always used basically against the weaker section of the society. This is a settled principle. I don't have to argue with illustrations. But now it has become so serious that any movement, and the movements are usually in the human history, is originated and motivated by the middle class intellectuals, lawyers. The Indian freedom movement was led by lawyers. Now the lawyers would ultimately be affected that if you organize civil disobedience movement and you are found to have organized it thrice, you should be thrown into jail. These are the broadly serious provisions. I am not taking you through the minuscule analysis of comparative laws. I think this is the time that we should join hands together and say that you cannot impose your idea of anti-people Hindutva philosophy simply by virtue of your majority in the parliament. What you are trying to pursue is a majoritarian rule, which is again against the basic principles of parliamentary democracy. The parliamentary democracy and our constitution teaches us, yes, the majority will govern, but they will govern with consciences. That's why the parliament. That's why the accountability. Now everything is going to be taken off. If they want to take it off, we have a responsibility. We have to join hands together. We have to fight together. And I'm really thankful to this JAAC who have organized such a convention. And I'm sure they will carry forward this message throughout the country. And I, on behalf of All India Lawyers Union, we have already launched campaign. We are trying to make the people understand why these laws are going to affect our rights. Otherwise, every lawyer says that I was practicing with IPC, I will practice with BNS. How does it affect me? But the affectation is much wider. That's why you have to join hands together to fight it out. I'm sure you can do this. With these few words, I thank you very much. Namaskar.